We had major oral argument in the United States Supreme Court in the United States versus Donald J. Trump case over whether or not Donald Trump, as the former president of the United States, has presidential immunity for misconduct that occurred around the election 2020 when he was the president. Big oral argument. Let's break it all down. I'm going to play some clips for you from the justices, and you're going to see a lot of things we've talked about on this channel came up before the Supreme Court itself. Stay tuned. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gun owner, constitutional attorney, member of the U.S. Supreme Court Bar, and author of Disarm: What the Ukraine War Teaches Americans About the Right to Bear Arms. All right, big oral argument. As you know, Jack Smith is the special prosecutor appointed by Merrick Garland to be independent, supposedly, specifically hired to go after President Trump, and that is what's been going on. And there are cases involving Jack Smith as a special prosecutor on behalf of the United States government suing Donald Trump for various things down in Florida dealing with classified documents, and also in the District of Columbia involving issues associated with the 2020 election and January 6th. Now, we've covered this, so I gave you some predictions about what was going on. You probably have seen me several times on Fox News and Fox Business with Maria Bartiromo discussing these issues, but I want to break it down for you here and now so you can hear some of the questions and back and forth between the lawyers and the Supreme Court justices during this oral argument over whether or not President Trump, as president, now that he's left the office, still has presidential immunity. So let's just start right here and right now. You're going to hear a phrase that we've talked about before, malum in se. We've talked a lot about that. I've tried to really instill this in you, that malum in se crimes are evil in and of themselves. They're murder, rape, robbery, fraud, and so on, in contrast to malum prohibitum crimes, which are crimes simply because the legislature says so. Short barrel rifle would be an example of this. The length of a barrel is an example of this, along these lines. So, nevertheless, it came up, believe it or not, very early in oral argument by Justice Sotomayor. Check out the discussion of malum in se in the context of presidential immunity involving Donald Trump right here.
It can be alleged, but it has to be proven. Malum in se is a concept long viewed as appropriate in law, that there's some things that are so fundamentally evil that they have to be protected against. Now, I think, and your answer below, I'm going to give you a chance to say if you stay by it. If the president decides that his rival is a corrupt person and he orders the military or orders someone to assassinate him, is that within his official acts that for which he can get immunity?
It would depend on the hypothetical, but we can see that could well be an official act.
It could, and why? Because he's doing it for personal reasons. He's not doing it like President Obama is alleged to have done it, to protect the country from a terrorist. He's doing it for personal gain. And isn't that the nature of the allegations here? That he's not doing these acts in furtherance of an official responsibility. He's doing it for personal gain.
I agree with that characterization of the indictment, and that confirms immunity, because the characterization is that there's a series of official acts that were done.
Now, what's very interesting here is, as we've talked about before, one of the problems or the issues of being a Supreme Court justice is, and this is something you may want to write down, to the parties involved in any case, criminal or civil, to the parties involved in any case, that case is very important to the parties. But it may or may not be precedential, meaning it's important to the parties, but may not be precedential to the whole society. If you're in front of the United States Supreme Court, usually not only is it important to the parties, in this case Donald Trump, it's also precedential for the whole country. And this is one of the things the Supreme Court justices clearly were concerned about, as they were going to have to set a rule. And they're going to have to set a rule in this case of whether or not a president who allegedly engages in a crime while president, whether or not he can be pursued criminally in an Article III in an Article III court after he leaves the White House. You can see Justice Sam Alito here talking about what it means to be a stable democratic society and the dangers that the Democrats could keep on prosecuting political opponents. Check out the video here.
All right, let me end with just a question about what is required for the functioning of a stable democratic society, which is something that we all want. I'm sure you would agree with me that a stable democratic society requires that a candidate who loses an election, even a close one, even a hotly contested one, leave office peacefully if that candidate is the incumbent.
Of course.
All right. Now, if an incumbent who loses a very close, hotly contested election knows that a real possibility after leaving office is not that the president is going to be able to go off into a peaceful retirement, but that the president may be criminally prosecuted by a bitter political opponent, will that not lead us into a cycle that destabilizes the functioning of our country as a democracy? And we can look around the world and find countries where we have seen this process, where the loser gets thrown in jail.
So I think it's exactly the opposite, Justice Alito. There are lawful mechanisms to contest the results in an election. And outside the record, but I think of public knowledge, petitioner and his allies filed dozens of electoral challenges, and my understanding is lost all but one that was not outcome determinative in any respect. There were judges that said in order to sustain substantial claims of fraud that would overturn an election result that's certified by a state, you need evidence, you need proof. And none of those things were manifested. So there is an appropriate way to challenge things through the courts with evidence. If you lose, you accept the results. That has been the nation's experience. I think the court is well familiar with that.
Now, what's quite interesting is, beyond what Justice Alito said there, that Justice Neil Gorsuch really made a very practical point. I think there's a lot of common sense on the Supreme Court, even though they're high IQ and very smart. Some common sense makes a little bit of sense. So here you have Justice Neil Gorsuch really pointing out that when the government is arguing, well, the motives of Donald Trump are bad, the motives were bad, here's Neil Gorsuch saying, well, every first-term president is basically motivated to be reelected. At least that's what his adversaries say. So how do we talk about intent or motive in this context? Just take a look at this and this discussion by Justice Gorsuch here.
And then I wanted to understand on the core immunity, or whatever word we use, that it seems to me that we're narrowing the ground of dispute here considerably. Do we look at motives, the president's motives for his actions? I mean, for example, he has lots of war powers, as we've discussed, but he might use them in order to enhance his election, his personal interests. Is that a relevant consideration when we're looking at core powers?
So I am thinking of this more as looking at the objective of the activity as opposed to the kind of subjective motive in the sense that Your Honor is talking about. I think that there is a lot of concern about saying an electoral motive to be reelected such.
Every first-term president, everything he does can be seen through the prism, by critics at least, of his personal interest in reelection.
Yes.
And so you wouldn't want that. I think you would say personal motivations off limits with respect to the core powers.
Probably, well, with respect to the core powers, we think those are just things that can't be regulated at all, like the pardon power and veto.
Right, regardless of motive.
Correct.
Regardless of motive.
That's right.
Okay.
That is right.
All right, so then we're in the non-core powers where we're fighting over. What role do motives play there? I mean, one could remove an appointee first of all, maybe ask this first, is removing an appointee, a presidential appointee, a core power or a non-core power in your world?
So here I might need to differentiate between the principal officers that this court in cases like Myers and Seal of Law has regarded as having a constitutional status of being removable at will from inferior officers where Congress does have some regulatory latitude to impose restrictions on removal.
Sure.
And
put that aside. Yeah, I understand that.
Putting that aside, yes, appointing a principal officer is a core power. I am not prepared to say that there is no potential criminal regulation to say you can't do it for corrupt purposes to enrich yourself, for example?
Well, now, again, we've talked about how the Supreme Court justices have to literally write a rule for the ages. Here's Justice Gorsuch pointing this out, that when they decide this case involving Donald Trump, they're not just deciding this case for Donald Trump, they're deciding this case for future presidents, including possibly even President Joe Biden. Check this out.
And we said, gosh, Nixon versus Fitzgerald, that's something courts shouldn't get engaged in because presidents have all manner of motives. And again, I'm not concerned about this case, but I am concerned about future uses of the criminal law to target political opponents based on accusations about their motives, whether it's re-election or who knows what corrupt means in 1512, right? We don't know what that means. Maybe we'll find out sometime soon. But the dangerousness of accusing your political opponent of having bad motives, and if that's enough to overcome your core powers or any other limits, reactions, thoughts?
Yeah, so I think that you're raising a very difficult question.
That's the idea, right? I mean,
that is the idea.
Testing the limits of both sides' arguments.
And I'm going to say something that I don't normally say, which is that's really not involved in this case. We don't have bad political motive in that sense.
I understand that. I appreciate that, but you also appreciate that we're writing a rule for the.
Now, we can't do one of these videos without talking about Justice Brown Jackson, the same justice that during her confirmation hearing apparently cannot define what a woman is. Nevertheless, let's talk about Justice Jackson for a second, where she's trying to point out, and I think you'll find this very interesting, she literally is trying to convey the notion that the president is not the only important person in the world making decisions. So she's literally trying to compare the job of the leader of the free world, the president of the United States, the person that holds the nuclear football, and then somehow is comparable and similar to other CEOs or other executives or who knows what. I'll let Justice Jackson speak for herself with this comment here.
To the extent we're worried about, like, how do we figure out whether it's private or public, we have to understand that we're only doing that because of an underlying assumption that the public acts get immunity. So let me explore that assumption. Why is it, as a matter of theory, and I'm hoping you can sort of zoom way out here, that the president would not be required to follow the law when he is performing his official acts? Everyone else, there are lots of folks who have very high-powered jobs, who make a lot of consequential decisions, and they do so against the backdrop of potential criminal prosecution if they should break the law in that capacity. And we understand and we know, as a matter of fact, that the President of the United States has the best lawyers in the world. When he's making a decision, he can consult with pretty much anybody as to whether or not this thing is criminal or not. So why would we have a situation in which we would say that the president should be making official acts without any responsibility for following the law?
I respectfully disagree with that characterization. The president absolutely does have responsibility. He absolutely is required to follow the law in all of his official acts. But the remedy for that is the question: could he be subject to personal vulnerability, sent to prison for making a bad decision after he leaves office?
But other people who have consequential jobs and who are required to follow the law make those determinations against the backdrop of that same kind of risk. So what is it about the president? I've heard you say it's because the president has to be able to act boldly, make kind of consequential decisions. Sure, but again, there are lots of people who have to make life and death kinds of decisions, and yet they still have to follow the law. And if they don't, they could be sent to prison, et cetera, et cetera. So
I'd say two things in response to that,
Yes.
both from Fitzgerald. That's the very sort of inference or reasoning that this court rejected.
Now, again, what's kind of funny here is that one of the attorney for President Trump responds to Justice Brown Jackson in terms of how this sort of impeachment, presidential immunity stuff works. So check out this back and forth between Donald Trump's attorney and Justice Brown Jackson here.
Let me put this worry on the table. If the potential for criminal liability is taken off the table, wouldn't there be a significant risk that future presidents would be emboldened to commit crimes with abandon while they're in office. It's right now the fact that we're having this debate because OLC has said that presidents might be prosecuted. Presidents from the beginning of time have understood that that's a possibility. That might be what has kept this office from turning into the kind of crime center that I'm envisioning. But once we say, no criminal liability, Mr. President, you can do whatever you want, I'm worried that we would have a worse problem than the problem of the president feeling constrained to follow the law while he's in office.
I respectfully disagree with that because the regime you've described is the regime we've operated under for 234 years. There has not been an expectation based on 234 years of unbroken political.
All right, let me ask you
conviction.
another question.
Now, to understand what's going to happen here, just conceptually, the issue is when Donald Trump was president, what actions did he take that were in his official capacity as president versus, let's say, his private capacity? So there are situations where a president of the United States engages in private conduct, I presume, and that's what was discussed. But when is that, where exactly is that line? Certainly Donald Trump, to the extent he's hanging out with his family, is likely engaged in something private, for example. That is much different than, let's say, appointing people to the Supreme Court or making legislative decisions, or I should say decisions about legislation, or, speaking to the American public from the bully pulpit, whatever you want to say. So nevertheless, this distinction between official acts on the one hand or private acts on the other hand came up several times. Where exactly is that line? And what is a private act of the president and what is an official act? Check this out now.
So any official act, so then in that world, the real decision-making from the court standpoint is whether or not something is an official act or not, correct?
That is an important determination by all means.
I mean, that's the determination in the absolute immunity world, because if you determine that it's an official act, then the principle is that you get immunity for it, correct?
That is correct.
All right. So my question, and I think the Chief Justice may have asked this at the beginning, is how do you determine what, or maybe Justice Thomas, how do you determine what is an official act? And when we're talking about the kinds of scenarios that Justice Sotomayor brought up, one could say that when the president is using the trappings of his office to achieve a personal gain, then he's actually not acting officially, even if the doctrine was absolute immunity. So what do you say about that?
Two things in response to that. First, to the last point, that allegation that this was really motivated by an improper private purpose could be made in every single case.
No, I understand that, but it would have to be made. I'm just trying to assess. Even if we had the doctrine of absolute immunity, that same allegation and the facts related to it would come in because the person would be arguing that he was not acting in his official capacity. He wasn't doing something official. He was doing it personal, correct?
I agree. The objective, or I'm not sure I agree, but the point I would make in response to that is in Fitzgerald against Nixon, this court emphasized that would result in an intrusive discussion or determination of the president's personal motives for every official act. And again, this is not just in the case of
Now, Justice Barrett got into the act because she also asked about the distinction between official acts of the president and private acts by the man. Here's what she says here.
Go ahead. So you concede that private acts don't get immunity?
We do.
Okay. So in the special counsel's brief on pages 46 and 47, he urges us, even if we were to decide or assume that there was some sort of immunity for official acts, that there were sufficient private acts in the indictment for the case to go back and the trial to begin immediately. And I want to know if you agree or disagree about the characterization of these acts as private. Petitioner turned to a private attorney, was willing to spread knowingly false claims of election fraud to spearhead his challenges to the election results. Private?
As alleged. I mean, we dispute the allegation, but
of course.
Sounds private to me.
Sounds private. Petitioner conspired with another private attorney who caused the filing in court of a verification signed by petitioner that contained false allegations to support a challenge.
That
Private.
also sounds private.
3 private actors, 2 attorneys, including those mentioned above, and a political consultant helped implement a plan to submit fraudulent slates of presidential electors to obstruct the certification proceeding, and petitioner and a co-conspirator attorney directed that effort.
You read it quickly. I believe that's private. I don't want to.
So those acts you would not dispute. Those were private, and you wouldn't raise a claim that they were official.
As characterized. What we would say, Your Honor, if I may, what we would say is official is things like meeting with the Department of Justice to deliberate about who's going to be the acting Attorney General of the United States.
Sure.
Communicating with the American public. Communicating with Congress about matters of enormous federal concern.
Thank you.
And again, of course, the topic of impeachment has come up. We've discussed this. Is the only remedy really available to go after a sitting president or someone that was president is to impeach him? In other words, if the president does something so terrible and illegal, the remedy is to impeach him and remove him from office. Because at the end of the day, the idea, you don't want the president worrying about criminal cases, you want the president worried about political punishment so he or she doesn't misbehave. Let's talk about this impeachment issue. Let's check it out here.
So, Mr. Sauer, you've argued that the impeachment clause suggests or requires impeachment to be a gateway to criminal prosecution, right?
Yes, I think that's the plain meaning of that second phrase in the clause.
Okay, so there are many other people who are subject to impeachment, including the 9 sitting on this bench, and I don't think anyone has ever suggested that impeachment would have to be the gateway to criminal prosecution for any of the many other officers subject to impeachment. So why is the president different when the impeachment clause doesn't say so?
Someone very important has made the opposite suggestion as to the president himself, which is Solicitor General Bork, which is reaffirmed in the OLC opinions on this, where Solicitor General Bork in 1973, as to the issue of the vice president, reviewed the historical materials, and he said the sequence is mandatory only as to the president. That is DOJ's view of the original understanding of the impeachment judgment clause, which is exactly our position. The sequence is mandatory only as to the president. Keep in mind that the criminal prosecution of a president prior to impeachment contradicts, in our view, the plain language of the Constitution, but also hundreds of years of history. And what DOJ admits is the framers' intent. And so we say that that practice, whatever its validity, should not be extended to this novel context where it clashes with the constitutional structure.
What if the criminal conduct isn't discovered until after the president is out of office? So there was no opportunity for impeachment.
We say the framers assume the risk that of under-enforcement by adopting these very structural checks. As Justice Scalia said in Morrison against Olson, the separation of powers prevents us from righting every wrong, but it does so that we do not lose liberty.
Okay.
Now, one of the things we talked about on this channel beforehand is these issues associated with special counsel Jack Smith. Is he constitutional? Now, this, I take it, is somewhat of a bad sign that the Trump lawyers may not have preserved the argument about Jack Smith, because the issue that Jack Smith lacks the legal authority to bring these cases against him was raised in an amicus brief. So let's see this question from Clarence Thomas on this issue right here.
Did you, in this litigation, challenge the appointment of special counsel?
Not directly. We have done so in the Southern District of Florida case, and we totally agree with the analysis provided by Attorney General Meese and Attorney General Mukasey. And it points to a very important issue here, because one of their arguments is, of course, that, we should have this presumption of regularity. That runs into the reality that we have here an extraordinary prosecutorial power being exercised by someone who was never nominated by the president or confirmed by the Senate at any time. So we agree with that position. We hadn't raised it yet in this case when this case went up on appeal.
I should also note that Justice Kavanaugh had a real discussion here about the Morrison versus Olson case, and Justice Scalia's view that it's improper to have special counsels because the last thing you want in American society is to have a particular person appointed to go get, let's say, Donald Trump, and then they basically search for a crime to get Donald Trump on, which is basically what happens here, where they say, hey, we want you to go after Donald Trump. And next thing you know, Donald Trump's been indicted in Florida by Jack Smith. He's being indicted in D.C. by Jack Smith. And we're not even going to get into the nonsense associated with the Fulton County, Atlanta cases or the New York City hush money case. Those are for separate videos. But it is interesting that Judge Kavanaugh does raise this issue of whether or not this is really appropriate and smart for American democracy to hire a person to just go after another person. Because inevitably, I believe it was Stalin that said this, show me the man and I'll show you the crime.
Justice Kavanaugh?
As you've indicated, this case has huge implications for the presidency, for the future of the presidency, for the future of the country, in my view. You've referred to the department a few times as having supported the position. Who in the department? Is it the president, the attorney general?
The Solicitor General of the United States. Part of the way in which the special counsel functions is as a component of the Department of Justice. The regulations envision that we reach out and consult, and on a question of this magnitude that involves equities that are far beyond this prosecution, as the questions of the court.
So it's the Solicitor General?
Yes.
Okay. Second, like Justice Gorsuch, I'm not focused on the here and now of this case. I'm very concerned about the future. And I think one of the court's biggest mistakes was Morrison versus Olson. Mm-hmm. I think that was a terrible decision for the presidency and for the country, and not because there were bad people who were independent counsels, but President Reagan's administration, President Bush's administration, President Clinton's administration were really hampered,
yes,
in their view, all three, by the independent counsel structure. And what I'm worried about here is that was kind of let's relax Article 2 a bit for the needs of the moment. And I'm worried about the similar kind of situation applying here. That was a prosecutor investigating a president in each of those circumstances, and someone picked from the opposite party, the current president, and usually was how it worked. And Justice Scalia wrote that the fairness of a process must be adjudged on the basis of what it permits to happen, not what it produced in a particular case. You've emphasized many times regularity, the Department of Justice. And he said, and I think this applied to the independent counsel system, and it could apply if presidents are routinely subject to investigation going forward. One thing is certain, however, it involves investigating and perhaps prosecuting a particular individual. Can one imagine a less equitable manner of fulfilling the executive responsibility to investigate and prosecute? What would the reaction be if, in an area not covered by the statute, the Justice Department posted a public notice inviting applicants to assist in an investigation and possible prosecution of a certain prominent person? Does this not invite what Justice Jackson described as picking the man and then searching the law books or putting investigators to work to pin some offense on him? To be sure, the investigation must relate to the area of criminal offense specified by the statute, but that has often been, and nothing prevents it from being very broad. I paraphrased at the end because it was referring to the judges.
Yes.
That's the concern going forward, is that the system will, when former presidents are subject to prosecution, and the history of Morrison versus Olson tells us it's not going to stop. It's going to cycle back and be used against the current president or the next president and the next president and the next president after.
All right, so let's wrap it up with this. There's a quick discussion about the founding era history. Remember how we've talked about that history plays a major role. Here's an example where the attorney is arguing to the United States Supreme Court about founding era history, which, as you know from this channel, because I'm turning you into the smartest person in the room when it comes to a lot of that stuff, you'll see this kind of argument that sounds very similar to things that I try to teach you here at the Four Boxes Diner. Check out this argument before the Supreme Court itself.
No. Now, there might be a different argument made about whether a statute or whether a statute as applied to particular conduct is properly available against the president. But that's a very different argument than the immunity claim that you're making here, which OLC has definitively not supported.
I don't know if I put it that way. I don't recall an opinion directly addressing it, but more fundamental to us, Your Honor, is in fact the language of cases like Marbury and statements like made by Benjamin Franklin at the Constitutional Convention, statements of George Washington talking about the massive risk of factional strife and how that could destroy the republic and erect a new government on the ruins of public liberty. That's what we rely on principally here. I cite the OLC opinions because, of course, what you see there is a very strong trend that if there's any statute that might trench in any way on the president's prerogatives, which they interpret it to avoid that.
All right, folks, so here's what I think is going to happen. The Supreme Court is going to say that it is conceivable that Donald Trump, as an ex-president, could be held criminally liable for something he did as president. However, I think they're going to articulate a standard whereby the lower courts are now going to have to determine what parts of the indictment, if any, are satisfied or no longer are satisfied, and whether or not any parts of the indictment can go forward. I think that you're going to see some sort of a very detailed line drawing game going on here. It's not a game, it's very important. And then this case will be sent down to the lower courts for them to conduct further analysis. So I think the reality is that these cases by Jack Smith are unlikely going to be tried before the November 2024 election. I think that is the practical outcome of all of this. As to what the law of presidential immunity, I think it'll be very interesting what lines are drawn here, but for all intents and purposes, I think it will give Donald Trump a chance to get presidential immunity, but it will not be just an absolute blanket. Anything the president does at any time can never subject him to criminal liability. I don't think it will be that broad, but I think it will be extremely broad and overall favorable to President Trump, but I don't think it's going to get him out of the woods entirely on this, at least as of right now. Now, we'll cover a few additional videos on this, because I think it's important to learn about the Constitution, the Supreme Court, and how these things work. I think this is an important case to learn a little bit about. I think what you learn about the Trump case can help you in Second Amendment and other constitutional issues. So we'll probably do a couple more videos over the next week or so on this Trump case. I think it'll be helpful for your ongoing education involving the Constitution here at the Four Boxes Diner. So there you have it. Hope you learned something here today. Make sure you subscribe. We're trying to get to 150,000 subscribers as fast as we can here on the channel. Don't forget to follow me on X at Four Boxes Diner, and we will see you again soon here at the Four Boxes Diner.
Orders up. Table 2A.